Peter Dauberman, the lawyer representing rape-accused Nigerian pastor Timothy Omotoso, has asked presiding officer Judge Mandela Makaula to recuse himself from the case. Dauberman told the court that his clients, Omotoso and his co-accused, want Makaula to excuse himself from the trial and allow another judge to take over. Omotoso and his co-accused Lusanda Solane and Zukiswa Sito face a litany of charges ranging from human trafficking to sexual assault and rape. In an affidavit read out in court, Omotoso said Makaula's comments wishing the state witness Cheryl Zondi well for her exams were biased against him. She's a university student at the University of Johannesburg. This morning, Dauberman told the court that the two accused in the Omotoso rape trial have been excused from court today in fear of their lives. This follows incidents where the two women, Lusanda Solane and Zukiswa Sito, and their supporters were allegedly mobbed and drenched in water. The same happened to Dauberman and Omotoso's wife, Taua, last week. Dauberman said there were too few police deployed at court. He also referred to false media reports saying they are an attack on the judiciary. Dauberman has expressed his concern that neither he nor the accused can come to court safely. He said it's the judge's duty to ensure a fair trial. Judge Mandela Makaula told the court that he did not have jurisdiction to allow for security. He added that if the lawyer and his clients were attacked, they should report it to the police and open a civil case. Well, Judge Mandela Makaula has dismissed the application from Omotoso's defense team to recuse himself. Following this, Dauberman has requested that the trial be paused until 2 p.m. on Thursday. This is in order for special counsel to appeal against the judge's decision not to recuse himself at the Supreme Court of Appeal. Well, I'm joined now by Attorney Ulrich Roux to just give us his views on what's going on with the case. Thanks very much for joining us, Ulrich.
Hi, good afternoon. Thank you for having me.
You're welcome. So what do you think the prospects are of success with this application that the defense is going to take to the Supreme Court of Appeal?
Well, I think that we must remember what the duties of a presiding officer are, and that is to at all times remain objective and to all times ensure that a fair and a speedy trial takes place in front of him. Now, the accusations were that the judge should have recused himself as a result of him being acting in a favorable manner towards the witness, in wishing her good luck with her exams, and in saying that she should not be concerned with the remainder of these proceedings. And the accusation then leveled against the judge was that this means that he was acting in a biased manner towards the witness, that he was not acting in an objective manner, and that he should accordingly recuse himself. Now, if it is proven that a judge has a personal interest vested in a matter, or he has a personal relationship with any of the parties before the court, such as the accused or a witness or the defense attorney or the prosecutor, then a strong argument could be made out that he should recuse himself, because it can be seen that he's not acting in an objective manner as a result of his personal relationship with any of these parties before him. The same can be said when he displays acts of kindness, which does not have a proper place in a court of law. But I do not think that anything that he did warrants him having to recuse himself. I think that it is common cause that the witness is a university student, that she needs to write exams at the moment, and there is nothing that she can do going forward in these proceedings. She was called to testify. It is in the interest of justice for her to do so. She was extensively cross-examined to test her evidence and to test whether it is truthful or not, and to test whether she can accurately recollect what occurred when this incident took place. And I think that the judge was well within his scope to interact with the witness in the way that he did, but also to ensure that the witness was not extensively cross-examined on issues which could not pertain any further clarity to the court, and to make sure that she was not personally attacked, and her character, and that she was not, verbally attacked and assaulted by the cross-examination. And I think that the judge did a good job and has acquitted himself well of his job thus far in this matter. Obviously, it is in the interest of the accused person for his defense counsel to be on a good footing with the judge and to see eye to eye with the judge. So, it could also be a strategic application. That's for the judge to recuse himself because if this is how matters unfolded when the first witness was called, then it certainly does not bode well for the defense going forward in this matter.
And the other additional 48 people that are set to also give testimony.
Exactly.
But just tell us, people took great exception to the line of, questioning that Dauberman exposed or subjected Cheryl Zondi to. Objectively speaking, as a person of legal experience, do you think that he did say things and do things that were below the belt, or it's pretty much standard?
The difficulty in this matter is the charges that the accused are faced with. It is sexual offences, it is rape, it is human trafficking. So the cross-examination of a witness when she says that she was raped by one of the accused is always going to be of a very personal nature. That being said, the cross-examination must have, the only goal that cross-examination must have is to either provide clarity to the court or to the defense counsel or the prosecutor, or to test the veracity and the honesty of the testimony given by the witness. And if it exceeds those lines, then it should not be permissible. And I think that is what people had difficulty with, is that the questioning was of a very, very personal nature. But unfortunately, given the charges that the accused are facing, it must be of a personal nature. I think a lot of the questioning could have been rephrased differently, because it did seem as if he was attacking her character and her personality, which one should always stay clear of. But in general and as a whole, I do not think that the majority of the questioning was uncalled for, and I think that the judge acted correctly thus far in stopping the defense counsel with proceeding on a certain line of questioning and making sure that he focuses on the matters before the court, and that is purely as to what transpired on that evening that the witness claims she was raped by one of the accused.
All right, Ulrich, we're going to leave it there. Thank you very much for your time, sir. That was Ulrich Roux. He's a legal expert, just giving us his assessment of what's been happening on the Omotoso case. Several high-ranking politicians are attending the trial today. Amongst them are Eastern Cape Premier Phumulo Masualle, Communications Minister Nomvula Mokunyana, Deputy Minister for Water and Sanitation Pamela Chwete, and the Minister